Thank you very much for coming to our panel today. Our panel entitled Immigration, the Arizona Statute, and E Pluribus Unum. I am honored to be able to moderate today's discussion. This is, I don't think I have to tell anyone, a very emotional, passionate topic, as we saw certainly on television screens and cable networks across the country all summer long. Because it's such an emotional issue, I guess I, just by way of introduction, find myself oddly ambivalent about it. On the one hand, as a lawyer, I obviously feel very strongly about the rule of law and law enforcement. As an immigrant, I also feel strongly about the value of immigration as a bedrock component of what makes America great. So I have this odd ambivalence, but thankfully, I think we have today an all-star panel to help us wade through these emotional and thorny legal and constitutional issues. And hopefully they will help us get through them, and focusing in particular on the Arizona law. Unless you were on the planet Mars, you have heard that the state of Arizona has passed a law in the area of immigration enforcement that has triggered quite a bit of response from points left, right, and middle. The format for today, I will briefly introduce each of the speakers. Each speaker will have 8 to 10 minutes to give their opening statements. I'll note right now Congressman Lungren sends his regrets. He was supposed to be here today, but I hear there's a lame duck session down the street, so I guess they're busy doing something down there. So I'll introduce the panelists. Mr. Kobach will actually give a rebuttal after we do the introductions. I'll then open it up for questions amongst the panelists, and then we will certainly leave time for questions from the audience. I know, just by way of warning and preface, I know that everybody here is here and excited to listen to our distinguished group of experts, and it's because of that that the Society staff has asked me to really try to limit the issue to actual questions. And so please don't make me look bad to the Society staff. I really am going to try to enforce that requirement today. So we have 3 excellent speakers today. First, to start us off will be Roger Clegg, President and General Counsel of the Center for Equal Opportunity. The Center is a conservative research and educational organization that specializes in civil rights, immigration, and bilingual educational issues. Mr. Clegg has held a number of positions, sounds like pretty much virtually every senior position at the U.S. Department of Justice, from assistant to the Solicitor General to the number 2 official in both the Civil Rights Division and the Environmental Division. I hasten to point out that he is a graduate of Rice University, which is where my distinguished wife went to school, and I'm not nearly as impressed by the fact that he went also to Yale Law School. Kris Kobach, we are honored to have him here. He is the recently elected Secretary of State from the state of Kansas, senior counsel at the Immigration Reform Law Institute, and most recently also a professor of law and Daniel L. Brenner Scholar at the University of Missouri, Kansas City School of Law. He has litigated a number of truly high-profile lawsuits across the country in the field of immigration. Perhaps his most important role is with regard to the very statute we're talking about today. For those who have worked on Capitol Hill or otherwise, you know that there are, when it comes to legislation, there are authors and there are authors, and he is the latter. And he too hails from the great Yale Law School, I suppose. Finally, wrapping up for us is Margaret Stock, who is an adjunct faculty member in the Department of Political Science at the University of Alaska, Anchorage. She's an expert in immigration, citizenship, national security, military affairs, and constitutional law. Previously taught at the U.S. Military Academy, West Point, New York, and is a member of the American Bar Association Commission on Immigration. She, unlike our other panelists, is from Harvard Law School, which is our nod to diversity on the panel. With that, Roger, would you start us off?
Well, thank you very much, Jim, for that very nice introduction. I'm going to talk about 5 mistakes that I think some conservatives are making with respect to immigration. The 5 mistakes are, number 1, neglecting the importance of assimilation in the public debate we're having. Number 2, opposing birthright citizenship. Number 3, supporting racial profiling. Number 4, supporting state and local involvement in immigration policy making. And then finally, a failure to strike a pro-immigrant tone in what we have to say on this topic. Now, I hasten to say that these are not errors that all conservatives are making. And I'm also want to be clear that these are not conservative mistakes. That is, I think that conservatism would, rightly understood, would ensure that these mistakes were avoided. I'm also going to be focusing more on the first and last, that is the failure to talk enough about assimilation and the failure to strike a pro-immigrant tone, rather than the other 3. I'm going to be talking about the Pluribus Unum part of the panel title. I think that the other 3 topics are more technical, and I know that 2 of the 3 are probably going to be talked about in more detail and more expertly by my 2 co-panelists. But anyway, so that's sort of a roadmap of what I'm going to be saying today. I believe that assimilation is the greatly neglected part of the immigration debate that we're having. Conservatives differ on what the appropriate level of immigration should be. I happen to be somebody who believes that America needs a fairly high level of immigration, and that we can successfully assimilate immigrants. But obviously a lot of conservatives disagree about that. Where I think that we can have some common ground is on talking more about how successfully to assimilate the immigrants that we have at whatever level of immigration we have. And I don't think that there's been enough discussion of that. Assimilation is important, for obvious reasons, and I think that there's a lot. It's particularly unfortunate that conservatives aren't talking more about this topic, because I think that conservatives have the most intelligent stuff to say about it. For instance, bilingual education is a bad idea. The focus should be on teaching kids to speak English as quickly as possible. That's the most important thing that our public schools can do, and bilingual education simply doesn't do that. Printing ballots in foreign languages is a bad idea, and yet federal law requires that in many jurisdictions. Politically correct textbooks are a bad idea. There are a whole variety of things that the government can do better in this area, and there's a lot that the little platoons can do in this area too. I'm not suggesting that everything that needs to be done in the area of assimilation should be done by the federal government. I think to the contrary, there's a lot that can be done by mediating institutions. Just briefly. I've made a list of 10 things that I think are essential for all Americans, 10 characteristics that I think are essential for all Americans, including Americans who are already here and may have been here for generations. And I'm just going to run through the list, and then maybe we can talk more about it. When I talk about this at law schools, particularly at Federalist Society events, I always put this list on the board, and then I invite comments. from the audience on things that ought to be added to it and things that ought to be deleted. It's always, interesting. But anyway, here's my list. Number one, don't disparage anyone else's race or ethnicity. I mean, these are things that we have to have if we are going to have a successful, multiracial, multi-ethnic society. Number two, respect women. Number three, learn to speak English. We have to be able to communicate with one another. Number four, be polite. I modify that when I have events in New York City, but that's... Number five, don't break the law. Number six, don't have children out of wedlock. Number seven, don't demand anything because of your race or ethnicity. Number eight, don't view working and studying hard as acting white. Number nine, don't hold historical grudges. And number 10, be proud of being an American. It's an interesting exercise, to sort of ask yourselves, what are the things that we really should be demanding of people, when they come here, and of people when they're already here. I mean, obviously, we can't demand that they all vote Republican. We can't demand that they all listen to the same music, eat the same foods, dance the same dances. There are a lot of characteristics that we're perfectly happy for there to be, pluralism. But what are the things that are essential? So anyway, that's my list of 10 things. Let me just briefly touch on the three sort of specific quasi-constitutional issues. Birthright citizenship. With all respect to John Eastman, and I was somewhat relieved to find out that he's actually moderating a panel at this very moment, so I'm not going to have to argue with him, but he is somebody who's argued that the Constitution actually does not require birthright citizenship. I disagree with that. I think that it does. And we're not going to amend the 14th Amendment. That's not going to happen. And I don't think it needs to be amended. I don't understand, the arguments that there is a problem or a significant problem with birthright citizenship. With respect to racial profiling, as conservatives, we argue all the time that the government should not be treating people differently because of skin color and what country their ancestors came from. And, we argue that in government contracting, we argue that in college admissions, we argue that when you're hiring firefighters, and we just lose all credibility if we say that, oh, well, but there's an exception. It's okay for federal, state, and local government officials to take ethnicity into account in deciding whom to stop, when they're doing an immigration sweep or something like that. It's a bad idea. I hasten to say that the Arizona statute that we're going to be talking about today avoids that problem. On its face, we'll see how it's implemented. But of course, any statute can be implemented in a racially discriminatory way, and I'm hopeful that will not happen in Arizona. But as finally passed, the Arizona statute, as I think Kris will probably talk about, does not include racial profiling, and I think that's all to the good. With respect to state and local involvement in immigration policy, as a conservative, I generally prefer, private actors over public actors and local over state and state over federal and so forth. But, immigration policy is an element of foreign policy. It is something that really, where the shots have to be called by the federal government. And the federal government may be doing a lousy job in what it's doing, but that is, I think, no justification for the states to step in. I mean, if the federal government were doing a lousy job in the way it was naturalizing citizens, that would not mean that it would be okay for states to start doing the naturalization, on their own. The argument is also made that, well, all the Arizona law does, or all these, different proposals do, is simply require the federal government to, the Congress has passed these statutes, and this is just ensuring that they're going to be enforced. But immigration policy involves more than just the mechanical, any kind of, executive branch execution of the laws is not done mechanically. And I think particularly in this area, it has to be acknowledged that the federal government ultimately has to call the shots in making the basic policy decisions of how immigration statutes are going to be enforced. The last thing I want to talk about is the importance of striking, how am I doing on time, by the way? All right. The importance of striking a pro-immigrant tone in what we say. And again, I want to make it clear that this is not a failure of all conservatives in talking about these issues, but it is a failure of some conservatives. There's nothing wrong with people wanting to come to the United States. There's nothing wrong with people wanting to come to the United States looking for better lives for themselves and their families and for jobs. And that is the overwhelming reason why we have immigrants and why we have illegal immigrants. The appropriate analogy is not people trying to break into a candy store. And we've got to beat them out of our candy store to keep them from getting in. That is not the way to look at it. I think a better analogy would be that, we have America is a lifeboat. And lots of people want to get into the lifeboat. Now, we can't have everybody get into the lifeboat at once, because then the lifeboat sinks, and that's bad for everybody, okay? You have to wait your turn. You may have to direct people, well, we're almost full, you're going to have to wait, you're going to have to go over this lifeboat over here or something, at some point my analogy breaks down. But, the basic point is there's nothing dishonorable or wrong about people wanting to come here. And wanting to become Americans. It would greatly simplify our foreign policy if everybody were an American. It's not a bad thing. We should want people to be Americans, and not just our president, but everybody. Or to use
debates in another room, not for this room.
Or to use another analogy. It's kind of like a 16-year-old who wants to join the Marines. Now, 16-year-olds cannot join the Marines. Okay, that is against the law. You've got to wait a year or two. But our attitude when we catch a 16-year-old trying to join the Marines is not to vilify him and say, get the hell out of here. What are you doing? I never want to see you again. What a horrible thing this is you're trying to do. The attitude is, look, you're saying this more in sorrow than in anger. Kid, I admire your pluck. It's great that you want to be a Marine. We hope that someday you are a Marine. Come back. But we have rules. You can't be a Marine now. That's just not the way the system works. But we don't vilify the person. This is not an evil thing to want to become a Marine. It is not an evil thing to want to come to America looking for a better job for yourself. So, better opportunities for yourself and your family. So, I think that when we talk about immigration policy, when we talk about illegal immigration, that is an important point, I think, for us to bear in mind. Thank you very much.
Thank you, Roger. Mr. Secretary?
I think that's Secretary-elect, but I'll take it for now. Well, what I'm going to do in my presentation is talk about 3 mischaracterizations of SB 1070 that have been pretty prominent in the last 6 months, and then explain why it's on legally sound footing against the preemption challenge brought by the Obama Justice Department. But I'd like to begin by respectfully disagreeing with Roger's statement that state and local efforts to discourage illegal immigration should not be supported by conservatives or presumably by anyone else, for two reasons. First, if ever you have a serious and pervasive law enforcement problem of national dimension, I don't think anyone would seriously argue that you should address that problem with only one level of government and the other levels of government must stay out. So, for example, take the war on drugs or some other issue which is deemed to be a crime that needs to be addressed. No one would seriously say that if we were going to stop drug abuse and drug crimes, we would tell the federal government, no, DEA, stay out of it. This will all be taken care of at the state and local level. And nor would we say seriously that the DEA would tell the states and local governments, no, we don't want you to make any arrests. We'll do everything. If you have a pervasive law enforcement problem, you have to have coordinated effort and you have to have all levels of government working together or you will never solve the problem, period. The second point I would make in response is that illegal immigration is the ultimate unfunded mandate. The Heritage Foundation's Robert Rector and Kim, I can't remember her first name, they did a study of the fiscal impact of illegal immigration annually, and they found that the net fiscal impact, this was in 2007, of illegal immigration at federal, state, and local levels combined was $89.1 billion a year, net. That's after you take into account any taxes you might drive, any sales taxes, everything from gasoline to cigarette tax, you name it. You still are $89.1 billion in the hole, and only $10 billion of that deficit is at the federal level. The lion's share is at the state and local level. So when the federal government doesn't adequately enforce our laws, or in the case of the current administration chooses not to adequately enforce our laws, then the cost is borne by the states. And so looking at Arizona, the fiscal cost annually, now this is a gross figure, not a net figure, is $2.7 billion a year, somewhere between 2.6 and $2.7 billion a year in state expenses. The biggest ticket item there is K-12 education for children in illegal alien-headed households, as well as criminal incarceration costs. 20% of the inmates in Arizona detention facilities are illegal aliens. There are also incredible criminal costs. I'm sure you've heard about the case of Robert Krentz, a rancher killed on his own land in April, shortly before the law was finally passed. 240 kidnappings in Phoenix in 2008 alone. The vast majority of those associated with alien smuggling or by cartels that are involved in alien smuggling. So the fiscal and criminal impact are extremely large. And to say that a state should just ignore it or just not be able to deal with it, I think is difficult to support. Well, Arizona's SB 1070 started out, and indeed is, a common sense way of facilitating cooperation between state and local law enforcement and federal law enforcement, and by ratcheting up slightly the level of law enforcement in Arizona of our immigration statutes, of our federal immigration statutes. But few statutes have been so grossly mischaracterized, both by some members in the press as well as by people in Congress and by the administration, indeed. I'm sure that, well, before I mention the ways it's been mischaracterized, there's another interesting aspect of this law. This isn't Arizona's first step in the area of increasing state-level efforts to stop illegal immigration. This is actually the fourth of 4 steps. In 2004, Arizona passed Prop 200, making it the first state to stop providing public benefits to illegal aliens. Actually, California tried with Prop 187, but that was struck down, and Prop 200 was upheld. In 2005, Arizona passed the Human Smuggling Act of that state, which has been so vigorously enforced by Sheriff Joe Arpaio in Maricopa County with very good result, I would say. And in 2007, Arizona passed the Legal Arizona Workers Act, which was upheld by the Ninth Circuit by a 3-0 decision in 2009. It's currently before the U.S. Supreme Court. The Obama administration urged the Supreme Court to take cert. And now we have the 2010 SB 1070. With each step, Arizona has ratcheted up the level of enforcement one click, and it is working. People are self-deporting out of Arizona, and I would argue that that is ultimately the objective of law enforcement. You deter people from breaking the law, and when you stop breaking the law in the context of an illegal alien, that means you go back to your country of origin. And in the case of Arizona, we know that many of them are actually going back to the country of origin, not just going to California, which has the exact opposite approach, rewarding illegal immigration. Because we know this because in Sonora, the Sonoran legislature sent a delegation north to Arizona right after the Legal Arizona Workers Act went into effect in January of 2008, and the Sonoran legislators complained to the Arizona legislators that they were sending too many Mexican nationals home too quickly, and that the Sonoran infrastructure of housing and other facilities was not sufficient to handle the incoming load of Mexican nationals returning to Mexico. And so therefore, I guess Arizona was supposed to take care of the problem or the fiscal cost. So what about these mischaracterizations? Well, the first mischaracterization was by Eric Holder himself, who famously said on Meet the Press, sternly warning that the law has the possibility of leading to racial profiling, and then he had his somewhat embarrassing moment a few days later on April 13th, 2010, when in a congressional committee he was asked if he'd actually read the law yet, and of course he said no, he hadn't bothered to read the law. If he had, he would have noticed that SB 1070 prohibits racial profiling, as Roger mentioned, in 4 different places. It expressly prohibits an officer from enforcing the terms of the act based on a person's skin color, race, or national origin. So if an officer did engage in racial profiling, in almost all circumstances imaginable, any prosecution would not stick because the law would be violated in the process of making that arrest. Furthermore, you have all of the other protections against racial profiling that can be brought with a 4th or a 14th Amendment claim. So this law goes well beyond what a normal statute would do in prohibiting racial profiling. The second misconception is critics declared the law would require aliens to carry documentation. Here our president was perhaps the greatest purveyor of this misconception. He said, you may remember this analogy he made, he said, now suddenly, if you're going to the ice cream parlor with your children, you will be asked to produce you'll be required to carry documents. And the curious word in Obama's phrasing was suddenly. Evidently, no one briefed him before he went to the microphone that since 1940, it's been federal law requiring all aliens in the United States to carry on their person at all times certain federal documents. There's nothing sudden about this. The Arizona law simply said if you are violating that provision of federal law, which are found, and those provisions are found in 8 U.S.C. 1304 and 8 U.S.C. 1306, you are also committing a misdemeanor under Arizona law. So there's nothing sudden about it. Arizona was simply taking seriously the documentation provisions of federal law. And I find it somewhat ironic that so many on the politically correct left insist that we not use the term illegal alien, we use the term undocumented immigrant. And so when a state finally takes the word documented seriously, they go apoplectic. Well, the third misconception was that the law required police officers to start accosting people on the street and demanding documents from them. And this misconception was also fueled by President Obama's example. But Section 2 of the law requires very specifically that in order for its requirements to kick in, an officer must first make a, quote, lawful stop, detention, or arrest in the enforcement of any other law or ordinance of a county, city, or town of this state, end quote. So in President Obama's example, you're not going to get stopped because of your skin color or for any other reason if you're taking your kids to the ice cream parlor. However, you will get stopped if you come running out of the ice cream parlor with an ice cream cone in one hand and a bag of money in the other hand, and someone is shouting, "Stop thief." Then you will get stopped. But again, the president didn't feel that reading the law was evidently necessary before he made his comments. Now, the most common scenario in which SB 1070 will come into play is during a traffic stop. And of course, thousands of traffic stops happen all across this country and hundreds in the state of Arizona. Suppose a police officer pulls over a minivan on Highway 17 northeast of Phoenix at night for some traffic violation, and inside this Ford Windstar minivan there are 16 people crammed in head to toe. The second row of seats and the third row of seats have been pulled out. This is very common. I've been with Sheriff Joe's deputies when exactly this happens. And underneath the human cargo, there are some trash bags filled with drug cargo as well. This is the standard way of moving aliens and drug cargo out of Phoenix, which is the hub now for illegal immigration in the United States. And the external movement of the aliens is like spokes from the hub to the rest of the country. Well, what this law says is that officer, if he develops reasonable suspicion that the person is unlawfully present in the country who he's talking to, he should simply not turn a blind eye and act on that reasonable suspicion. Now, what constitutes reasonable suspicion? Well, there are more than 800 cases defining reasonable suspicion in the case of unlawfully present aliens, but it can be things, it has to be multiple factors. It can be things like traveling on a known human smuggling corridor. It can be things like no one in the vehicle having any identification documents whatsoever of any kind. It can be things like acting evasively when the officer asks any questions about where he's been, where he's going, or perhaps his immigration status. And so if you have those multiple factors, the officer should follow up on them. What does follow up mean? It means simply call the 24/7 hotline that has been around since the mid-1990s. It's called the Law Enforcement Support Center, and it's there for that exact purpose. And every day, on average, more than 1,300 calls are made by police officers all over the country to this hotline to find out if the person they're talking to in a traffic stop or some other law enforcement stop is indeed an illegal alien or not. And what Arizona's SB 1070 does, it simply says, all right, it's our state policy that uniformly in our state, everybody's got to do this. If you develop reasonable suspicion, go ahead, make the call from your squad car right there. That's all it does. It takes something that was done irregularly and is done irregularly all over the country. It makes it done uniformly in Arizona. There's some other provisions of the law prohibiting sanctuary cities, making it a crime to seek unlawful employment. I won't go into that right now. Well, we drafted SB 1070 with the full knowledge that the ACLU would sue. They always do. But our oversight is that we were only thinking about ACLU lawyers outside of the Justice Department. We didn't think of the ones inside of the Justice Department, and of course, they did bring suit, and this absolutely gratuitous and unnecessary lawsuit by the Justice Department, very strange. 5 lawsuits had already been brought by private litigants. There was no need for the Justice Department to rush in to get this issue teed up before the courts, because it was already before the courts. And it was also so unprecedented because of what it does. I'm aware of no other case where the Justice Department has sued a state that is attempting to help the federal government enforce federal law. I cannot think of any other precedent for this in American history. There's also something else disturbing about this lawsuit. You may remember that the cat was let out of the bag, that the lawsuit was finally coming when Hillary Clinton was traveling to Ecuador, and she was speaking to Ecuadorian journalists, and she said during that interview that President Obama would be directing the Justice Department to bring the suit. Now that fact in and of itself is disturbing, that President Obama is directing the Justice Department to bring the suit. Because when I was in the Justice Department, and many other people in this room have worked in the Justice Department, you know that one of the cardinal rules is the White House does not direct the Justice Department when to sue and whom to sue, or when to prosecute and whom to prosecute. But apparently that rule doesn't apply in this administration. And perhaps the most notable thing about the Justice Department lawsuit is what it did not contain. No reference whatsoever to racial profiling. How in the world can you bring a facial challenge against a statute that 4 times on the face of the statute prohibits racial profiling? So what did they bring? They brought a lawsuit based on preemption. And of course, the preemption principles are the fundamental notion of preemption is that Congress has passed a law that prohibits a state from doing what is being done and what is being challenged. Well, the problem here is that there is no express statute saying any such thing. Congress has never passed a law saying states can't do this. Indeed, Congress has passed many laws encouraging states to do things like this. So then they had to fall back, since they couldn't bring in an express preemption argument, they had to bring an implied preemption argument. And the implied preemption argument is a conflict preemption, that perhaps this law conflicts with the objectives of Congress, and that was their theory. Again, the only problem is there's no expressly stated objective of Congress in any statute that this conflicts with. And the United States Supreme Court has long recognized that states may take actions to discourage illegal immigration in their state. The last time the Supreme Court spoke on this was in 1976 in the case of DeConis versus Bika. That was a California law that prohibited the employment of unlawfully present aliens, and the California law was upheld by the U.S. Supreme Court. And the U.S. Supreme Court said that there is no preemption, that states can pass laws that touch upon immigration and discourage illegal immigration as long as they are harmonious state regulations that do not conflict with federal law. Justice Kennedy in Gade versus National Solid Waste Management in 92 said, furthermore, we've got to be careful about inviting a judicial inquiry to find conflict preemption in the nooks and crannies of any law. He said a freewheeling judicial inquiry into whether a state statute is in tension with federal objectives would undercut the principle that it is Congress rather than the courts that preempts state law. As for the provisions of the law that allow and encourage state police and local police to contact the federal government when they are making an arrest or they are in the course of a traffic stop, that has been upheld by every single circuit that has addressed the issue, including the 4th, 5th, 8th, 9th, and 10th circuits of the United States. So that is on very solid legal ground. And in 2005, a unanimous Supreme Court in Mueller versus Mina held that the local police officers have the authority to inquire into immigration status of individuals who have been lawfully detained without even having a reasonable suspicion that the person is an illegal alien. So Congress has, and on top of all of these precedents, Congress has taken steps to encourage states to do things to assist the federal government. Let me just give you a quick quote from the U.S. versus Alvarez, a 10th Circuit case in '99. Federal law evinces a clear invitation from Congress for state and local agencies to participate in the process of enforcing federal immigration laws. End quote. Okay. So what's their preemption argument? If there's no act of Congress that says even implicitly says states shouldn't be doing this, where's their argument? Their argument is this. Their argument is that even if Congress didn't preempt the states, the executive branch did. And the Obama administration chooses not to enforce certain immigration laws of the United States because we have made certain priorities, we're balancing our objectives, and we don't think that these laws requiring you to carry documents if you are an alien in the United States, we don't think those are very important, and so we are choosing not to enforce those, and our choice not to enforce those laws preempts the states. Now, this is absurd for two reasons. Number one, it makes a mockery of Article 2 of the Constitution, which says that the president shall take care that the laws are faithfully executed. And number two, it's absurd because the Supremacy Clause of Article 6, which is the basis of preemption, only comes into operation when Congress acts. Only laws of Congress or treaties ratified by Congress have preemptive effect. Unilateral executive actions, which are contrary to statutes which are presumed to be enforced, do not have any preemptive effect. And the implications of this argument are truly grave, I think, and I'll end it here. We're in a situation now where the executive branch is asserting that it can unilaterally preempt by choosing not to enforce a federal law, and that its choice not to enforce that law will have the constitutionally significant effect of pushing the states off the field. Our founding fathers designed preemption under the Supremacy Clause to be something that was very difficult to do. Only an act of Congress could preempt, or a treaty could preempt. If executive whim or an executive order can preempt, then we can just be pushing the states off the field willy-nilly at the will of the executive. Secondly, it's a usurpation of power from Congress, the usurpation of the preemption power. Now, unfortunately, the district judge who ruled in the case did not see the gravity of what the Obama administration was asserting, and it bought this argument, lock, stock, and barrel. I'm hopeful that the Ninth Circuit will realize what is at stake and will reject these claims, but I think everyone can agree, regardless of what you think about the Arizona law, that this notion of executive preemption is truly dangerous to our constitutional republic. Thanks.
Thank you, Mr. Secretary-elect. Margaret.
If you don't mind, I'm going to speak from up here because that way I can gaze upon you a little better than looking sideways. Well, Jim Ho forgot to tell you that a couple of things about my background, so I'm going to allude to them as we go along. But Roger, you'll be happy to know that there was once a United States senator who tried to join the United States military with fake documents, and he was turned away, and it wasn't held against him, and he eventually did go on to serve many decades in the United States Senate, and that was Senator Mike Mansfield, who tried to join, I think, when he was 14, using fake documents. Well, I'm from Alaska, so I have to disclose Alaska's dirty little immigration secret, which is that we're the only state in the union that has had an undocumented immigrant as its governor. Not that governor. No, that governor you're thinking of was a birthright citizen under the 14th Amendment, born in Idaho, but I have not seen her birth certificate. Alaska in the early 1900s had a territorial governor appointed by the powers that be in Washington, D.C., and his name was John Franklin Strong. He actually looked a lot like Kris here. But nobody checked his papers before they made him the territorial governor of Alaska, and for 5 years he governed our great state as a territory at the time, until his other wife showed up looking for him. So he wasn't just a non-citizen of the United States, but he was also a bigamist. I just gave you a little historical immigration tidbit, but now I wanted to talk a little bit more about some history, because we're here celebrating controlling government, the framers, the Tea Parties, and the Constitution at this year's annual National Lawyers Convention. And as a longstanding member of the Federalist Society myself, all the way back since law school, I need to remind everybody that way back when the founders were upset at King George, one of the grievances they had in the Declaration of Independence was that King George was stopping people from coming to America, that he was restricting immigration. And that's actually in the Declaration of Independence. as one of their grievances. So the founders were actually, looks like, open borders advocates. Okay. And then when it came to the Constitution, of course, the only thing explicitly found are two things. One, the power given to Congress to restrict human trafficking. Back then, of course, it was called slavery, and Congress was given the power after 1808 to restrict the importation of those persons. We'd call today people being trafficked into the United States. And Congress was also given the enumerated and exclusive power to naturalize people. We know from reading James Madison in Federalist 42 that this was because otherwise there would be sort of a race to the bottom as different states set different standards for citizenship. And so the founders felt it was extremely important, based on the examples they had seen among the colonies and the states in the Articles of Confederation, to make sure that there was one national uniform standard for citizenship. Now, that's not exactly relevant to the situation today, but it does shed some light on the concept of original intent. So what about the power to regulate immigration? Well, it's not found explicitly in the Constitution except for that human trafficking provision that I mentioned, but the courts have variously said that the power to regulate immigration is inherent in the power of sovereignty, that it comes from foreign affairs powers, as Roger alluded to, that it comes from the Commerce Clause. In the early days of the Republic, the states, in fact, did have some regulatory power, and they did regulate which people came to their states. But for more than 100 years now, we have had an almost exclusively federal power to regulate who gets to come to the United States, which immigrants get to come here. And in fact, the United States Supreme Court has said that Congress has the plenary or absolute power to regulate migration. Congress has exercised this plenary power to create an absolutely complex and now very dysfunctional web of laws that lies beyond the power of most people, including most lawyers, to understand. Immigration law today has become so technical and so complicated that it takes a good 5 years of actually practicing immigration law full-time for a lawyer to become competent enough to avoid regular malpractice claims. Now, you don't have to take my word for it, although I was a managing partner at a law firm for years that practiced just immigration, citizenship law, and related topics. And I know from trying to train associates how difficult the area of law is, and from trying to represent clients. But you don't have to take my word for it. You can just refer to some official sources. Department of Homeland Security spokesperson on the record in the Washington Post a few years back, quote, "Immigration law is a mystery and a mastery of obfuscation." Federal judges have been even less complimentary of the statutory mess that Congress has created. One federal judge called immigration law King Minos' labyrinth in ancient Crete. Another federal court case, the judge said, quote, "The tax laws and Immigration and Nationality Acts are examples we have cited of Congress's ingenuity in passing statutes certain to accelerate the aging process of judges." This complex web of laws is what Kris has been saying that the state of Arizona would like to help enforce. But this complex web of laws has today created an utterly broken and dysfunctional immigration system, one that hasn't served well our national economic security, our national cohesiveness, or our national security in general. Today we have a continuing crisis on our hands, one that successive presidents and Congresses have apparently been unable to resolve. And I'll just note, some of you may be out there reading decision points right now. If you've gotten to the part, there's an extensive part in there where President Bush talks about immigration and says that one of his great regrets is that he did not attempt to fix the immigration system before trying to fix Social Security, because he thinks he would have had a grand victory on his hand if he had reordered his priorities. Today, however, we know that during President Bush's administration, he was not able to get a comprehensive fix of this extraordinarily messed up and dysfunctional national statutory scheme. And so today we still don't have one. With rising violence on our southern border and violence in Mexico, millions of undocumented immigrants in the United States, massive law breaking going on, and Congress unable or unwilling to provide the legal fixes and the resources necessary to solve the problem, the states suffering the most have naturally decided to exercise their role as laboratories of democracy and attempt to step in where Congress has failed. So what role then is there for the states? Well, traditionally, the states have played a strong role in regulating non-citizens who reside within their borders. They enact statutes, often upheld, that regulate employment or benefits for non-citizens. Note to Kris, though, Decanis v. Bika was actually a case that predated IRCA, Immigration Reform and Control Act, in which Congress enacted an extensive and complex regulatory scheme over employment. So that case is probably not a good one to be citing today because it predates IRCA. Preemption doctrine, however, tells us, and the Supremacy Clause jurisprudence teaches us, that states can't conflict with or undermine the federal government when it comes to immigration matters. States are free to complement the federal government, and in some cases the federal government and Congress demand that they support federal efforts, but they can't undermine federal efforts. So what then about Arizona? Well, Kris gave you a very, very spirited argument, which I admire greatly, even though it's wrong, that Arizona is simply trying to help the federal government do its job. But I'll tell you that with all due respect, that view does not comport with the facts. Now, I'll tell you a little story here that I think illustrates well. James didn't tell you that I spent 28 years in the military police corps in the United States Army Reserve, and in the course of being a military police officer, I actually got to do traffic stops. So I'm very familiar with traffic stops, and I've spent a lot of time busting people for things. In the military police corps, our motto was bust them all and let JAG sort it out. But I observed a very interesting segment of Larry King Live just about the time the federal judge was getting ready to enjoin 4 provisions of the whole law. And another note, federal judge in Arizona only enjoined part of the law and not the whole law, the most egregious parts. But Larry King Live had 2 sheriffs from Arizona on the show. And the interesting thing about it was both sheriffs completely agreed on the facts. And one sheriff was completely opposed to the law, and the other sheriff was completely in favor of the law. Now, the first sheriff to talk was from southern Arizona, and he said, I don't like this law. The reason I don't like this law is because right now, if I find an unauthorized immigrant, I can take that unauthorized immigrant and turn him over to immigration. And they're off my hands, and I don't have to worry about it. When this law goes into effect, what I'm going to have to do is bust that immigrant under Arizona law, charge him with the crime, process them through my jail. They're going to be sitting in my jail for a while. They're going to get a defense lawyer. It's going to be a prosecution. They're going to get charged with a crime. They're going to get sentenced. And then at the end of it all, I'm going to turn them over to immigration. So he says, I think that's a big waste of time and resources, and I'd rather just be able to turn them over to immigration without having to go through all that when I don't feel it's appropriate. And the second sheriff said, well, I agree with that. That's exactly what the law is going to do, he said. But I'm from northern Arizona, and we don't have anybody to turn them over to. Okay? Now that illustrates to me exactly what people think this law is going to do. It's going to make the federal government come to Arizona and take 400,000 people off the hands of the taxpayers of Arizona. Arizona's law also explicitly contradicts the federal priorities in immigration enforcement as laid out by Congress and by the executive branch. It's not just the executive branch. Arizona states in its purpose statement that attrition through enforcement, meaning enforcing every single immigration law, is going to be the immigration strategy in Arizona. And yet, that is not the strategy of the federal government, nor is it the strategy enacted by Congress. Instead, Congress and the executive branch have together demanded prioritization of enforcement. Congress has given the executive branch, through resources, the maximum nationwide capacity every year to detain and deport only about 400,000 immigrants, the entire unauthorized population of Arizona, nationwide each year. And the executive branch has to decide its priorities nationwide. It can't just send every single immigration agent enforcement person to Arizona because Arizona demands it. Those limited detentions and deportations are aimed at the worst of the worst, the serious criminals, although to speak frankly, studies have shown lately that the executive branch is apparently not real good at that, but at least that's the official line that they're attempting to go after the worst of the worst. Congress has never given the Department of Homeland Security the resources to deport all the undocumented immigrants or unauthorized aliens in the country. By conservative estimate, that would cost about $80 billion to deport everybody who's unauthorized in the United States. And that's more than 20 times the current budget for immigration enforcement. Now, Arizona now wants all of these resources to be focused on Arizona and taken away from California and New York at least if you run the numbers, not letting the federal government decide those priorities. Now, Kris also said when you have a serious and pervasive law enforcement problem, you always get the states involved and you always have joint. Well, that's actually not true. Drunk driving is a serious and pervasive problem, but generally it's left to the states. Federal government doesn't get too involved in that other than mandating drinking ages and such, using federal highway funds. Speeding is a pervasive law enforcement problem that's generally left to the states. Federal tax fraud is an extraordinarily serious and pervasive law enforcement problem that the states don't help the federal government with. The federal government's left to on its own. So it's not the case that every single complicated and difficult law enforcement problem is always left solely to cooperation between both branches of government. But it's wrong to say that there is no state and federal cooperation on immigration. In fact, there's a huge amount of it. The difference is that it's laid out in a statutory scheme enacted by Congress. Congress has enacted Section 287G of the Immigration and Nationality Act, which lays out a very explicit procedure by which states can enforce immigration laws subject to the priorities and under the control of the federal government. What Arizona is doing is going well beyond that. Their help is not exactly what the federal government wants. The federal government would prefer that the state of Arizona use the existing statutory procedure 287G and not come up with its own plan for how it's going to help the federal government. And I'll give you kind of maybe a little bit of a silly example, but relevant. Why not pass a law saying because we have a huge deficit and we have rampant tax evasion going on in the United States, that states are going to help the federal government by checking everybody, they stop for a traffic violation to see if they filed their federal tax return and if they have any back taxes. We don't do that, and we would probably think that was silly. And if Arizona said, well, we're going to enforce federal tax law and we want all the IRS agents in the country sent to Arizona, there would no doubt be an outcry about that, particularly from Congress, which said there's only a certain number of IRS agents and there are enforcement priorities, and we're only going to go after the worst of the worst tax fraud offenders and not after Joe the plumber, who has relatively minor tax violations. As I said earlier, immigration law is extremely complex, and Arizona's law was not drafted by anyone who is expert in immigration law. Arizona's law criminalizes behavior that in federal law is not criminal, penalizes persons who don't have paperwork when such persons are not even given papers to carry by the federal government. Arizona's law also fails to recognize that it's not an easy matter to determine whether a given individual is removable from the U.S., which is why every year the Department of Homeland Security finds itself, even though it's supposed to be the expert on this stuff, accidentally deporting American citizens and removing people who have legal status in the United States. Such mistakes are not the least bit rare by any means. I can tell you that for a fact because as an immigration lawyer, I constantly had people coming into my office telling me they were illegal immigrants when in fact I figured out after an hour and some extensive checking of paperwork that they were U.S. citizens. So we have people who are running around the country thinking they're undocumented when they're U.S. citizens. We also have people running around the country who are think they're U.S. citizens when they're not. And this is all because Congress has enacted this extraordinarily complex and technical code that taxes the aging process of judges. Now, as I said, states are permitted to help federal officials with immigration enforcement, but it's supposed to be under the direction and control of the executive branch through such programs as INA 287G and through programs like the Secure Communities Program. Through these programs, states can cooperate with immigration enforcement, but they don't get to tell the federal government what to do. They don't criminalize immigration acts that are not criminal under federal law. And again, they act under the direction and control of the feds according to priorities set by the federal government. If you read the U.S. District Court opinion in Arizona, it's a conservative decision. It's a careful decision. The judge in Arizona applied straightforward principles of preemption. And you know out there's express preemption, there's conflict preemption, there's field preemption. And the judge carefully found lots of conflicts between the federal government's scheme as laid out by Congress and what Arizona was trying to do. And if you watched or heard the oral argument at the Ninth Circuit, you would be also aware that the Ninth Circuit is highly likely to rule against Kris. I'm really sorry. But it's pretty clear, and this was not a liberal panel. Carlos Bea, who speaks frequently in front of the Federalist Society and is speaking tomorrow, was one of the panel members, John Noonan, and then one judge who might be termed liberal, Judge Paez. But those three judges on the Ninth Circuit are highly familiar with the technical complexities of immigration law because the Ninth Circuit is the circuit in the country that has the most immigration cases. And they also know that immigration is so complicated that even their circuit gets it wrong and has to withdraw opinions that they have improvidently issued because they found somebody to be removable who turns out not to be, or they've dealt with situations where immigration judges have ordered U.S. citizens deported and then they've had to get them back in the country somehow. The theme of this conference is not only issues relating to original intent and constitutional conservatism, but the theme of the conference is also related to limited government and less spending. And in that regard, I'm a little regretful that the judge enjoined the law because I think if the law had gone into effect, it would have been rapidly apparent to everyone that the Arizona law flunks the cost-benefit analysis. Arizonans should therefore be just a little bit grateful that the administration stepped in to protect its enforcement priorities in the manner that it did, because apparently there was no cost-benefit analysis provided to Arizona legislators when they passed this law, and the costs of SB 1070, should it ever go into effect, are clearly going to outweigh the benefits. Now, Kris gave you some sources. I don't have time here, but I could cite to you piles of other studies going the other way that say undocumented immigrants are actually much less criminal than the regular U.S. citizen population, that many of the crimes being committed in Arizona are being carried out by people who are perfectly legal and can never be deported because they're Americans. But charging some 400,000 immigrants in Arizona with crimes, locking them up in Arizona prisons, providing them with food and medical care while they're locked up, paying for all the lawsuits, and you only heard about a few, but there's lots of them going on. And the plaintiffs are going to win a lot of them, just like the Hazelton case, which the Third Circuit decided against the folks that are on Kris's side there, again on preemption and supremacy clause grounds. Mistakes are inevitably going to be made. We were talking about racial profiling. The fact is that the federal government right now in enforcing immigration law has a terrible time. I'll just point to one case out there that is in the news, the Amway case, the famous Amway case. A group of Spanish-speaking persons from Denver, Colorado got on a bus provided by the Amway Corporation to its Spanish-speaking distributors who were going to go to an Amway convention in Omaha, Nebraska. And as the bus was driving along the interstate highway, people got hungry, so they decided to pull over at a McDonald's and get some breakfast. And a 19-year immigration veteran, Department of Homeland Security employee, heard them speaking Spanish and looked at the bus and concluded from the bus plus the Spanish speaking and the clothing that the individuals were wearing that this was a smuggling operation, and it's exactly what Kris was talking about that earlier when he was describing law enforcement approaches to these things. They arrested everybody, hauled them away, and turned out, of course, that they had grabbed some U.S. citizens who are now suing the Department of Homeland Security for racial profiling and having their rights violated because they were forced to get searched, taken to a detention facility, got mug shots taken of them, et cetera, et cetera. So it's not every single minivan that meets the description that Kris gave you earlier that's the subject of these things. It's just a fact that statistically we're going to see racial profiling happening because of the way the immigration problem has played itself out today. And all of this stuff is going to cost Arizona millions and millions of dollars. Arizona's governor may also be apparently unaware that under the recent United States Supreme Court decision in Padilla v. Kentucky, Arizona's criminalization of immigration law violations will mean that every non-citizen arrested under SB 1070 will be entitled to expert advice as to the immigration consequences of a conviction under SB 1070's provisions. This requirement happily will provide employment to immigration lawyers. And I'll just note one reason why Congress has not criminalized the act of being present in the United States unlawfully is because that would require Congress to fund lots more Article III judges, many more prosecutors, many more defense lawyers. If there are 8 to 20 million unlawful immigrants in the country and they turn into criminals overnight, it's extraordinarily expensive. Right now, Those folks' cases are handled administratively with limited due process. They have no right to a defense lawyer unless they can afford it or they find somebody to volunteer. This is a much less rigorous and cheaper system that allows for a maximum number of deportations, and the Obama administration is about to set a record in American history of deporting the most people from the United States in a single year that has ever happened before. Now, I don't have enough time to handle all the arguments Kris raised, but I guess we're going to have some Q&A time, so I'll get to come back to them. The bottom line is that Kris may argue that SB 1070 is a force multiplier for the federal government. It's going to help the federal government, but it's more accurate to say it's a ball and chain on the federal government. Under straightforward principles of preemption, SB 1070 fails, and I predict the Supreme Court is going to ultimately uphold the injunction against SB 1070. This will ultimately have the salutary effect of forcing Congress to do its job. Because if there's one thing that's clear from this immigration mess we're in, it's that the blame should be laid at the feet of Congress, which has not only enacted a complex scheme that makes absolutely no sense to most people who look at it, but Congress has also failed to provide the resources and the people necessary to enforce this complex scheme at the federal level. Thank you.
Thank you, Margaret. Kris, do you want a few minutes for rebuttal?
Yeah, I'll just take a couple seconds. More than a couple seconds. I'll just respond to a few of the points Margaret made. I found it interesting. She started off by talking about the founders and that provision in the Declaration of Independence, criticizing the king for limiting immigration. Yeah, that's right. They were advocates of more immigration from England. They were, if you go on and read what the founders went on to say in many of their writings in that era, they were very worried about too much immigration from countries that did not share the English common law tradition and that did not.
Germany.
Yeah, exactly. I know. My point is simply that they had a very narrow view of desirable immigrants, which would include probably everybody up here and many people in the room, including myself. I'm sure they weren't enthused about Norwegians and Czechs coming in. But the point is, they certainly weren't open borders advocates. And if you look at the Alien and Sedition Acts, which were passed by the first Congress, they weren't very enthusiastic about this open borders theory either. She says it's a broken and dysfunctional system, and the real solution to this problem is for Congress to finally act, and maybe that's the only good that will come of the Arizona statute. You know, I find it interesting. It's a familiar Washington conceit. If we have a problem, what we need is for Congress to pass a law, and then the problem will be solved, and then we can move on to another problem, because we've solved the problem now that Congress has passed a law. Well, of course, that's not true. In so many areas, Congress passes a law, and the law only compounds the problem. But the real question is it going to be enforced effectively in immigration law? And the statutes are not at all dysfunctional in immigration law. Our statutes, if they were enforced thoroughly and enforced across the country, and they were all enforced in a fairly systematic way, you would actually see the system start to work pretty well. So I think it's the dysfunctional system trope is one that you hear all the time in the media looking for a quick one sentence that everybody agrees is a dysfunctional system. Well, no, I'll agree that the current administration is not enforcing vigorously, but it's certainly not a dysfunctional set of laws. And having Congress wade in with a so-called comprehensive act will not make anything better. It will make it much worse. DeConis versus Bika, she says, don't rely on that case because DeConis predates IRCA. IRCA was passed in 1986, DeConis in 1976. Well, we do rely on that case because that's what the Supreme Court, when they last talked about it, and although several of the ACLU attorneys I've gone up against have said we should not rely on DeConis, every circuit that has been presented with that argument has rejected it and has continued to rely on DeConis because the Supreme Court's holding on how we address immigration preemption questions continues to be what every circuit continues to go by, and most recently, of course, the Ninth Circuit. She says that some areas of the country don't have enough ICE agents to pick up the illegal aliens that may be arrested by these police officers. That's certainly true. The Arizona law doesn't demand or require that the feds come running and must take custody of someone they discover. It merely gives the federal government the opportunity. That the phone call is made. If the federal government says we don't have anyone in that sector right now, it simply says don't turn a blind eye, give the feds an opportunity to pick up these individuals. She says it conflicts with Congress's strategy, Arizona's law does. Well, again, like Judge Bolton, she doesn't cite any actual statute that embodies or even mentions any such strategy of not enforcing certain laws or tempering the enforcement in certain parts of the country. Indeed, her argument boils down to, well, Congress hasn't given enough resources to the federal enforcement agents to enforce all of our laws vigorously, so therefore Congress's strategy is implicitly that Congress wants the states to enforce some laws and not others, or maybe only enforce immigration laws against people who have committed other crimes and not others. None of this is spelled out in any congressional statute, but evidently we're supposed to imagine this strategy, find it in the penumbras and emanations of other things Congress does, but there is no such strategy of non-enforcement that Congress has ever adopted. And finally, she says the federal government would prefer that Arizona use the existing statutory procedure of 287G. 287G, if you're not familiar with it, is the process by which a state can have a formal agreement. About 67 jurisdictions around the country have these, where they deputize some of their law enforcement officers to have become basically deputy ICE agents and have federal law enforcement powers. Well, that's funny. The Obama administration is actually dismantling the 287G program right now. You may be familiar with the fact that they're scaling back the authority that states and counties have. Most notably, Sheriff Joe Arpaio, Maricopa County is the jurisdiction that has been most aggressively using this 287G authority, and the federal government has been, the Obama administration has been making every effort to stop the use of that. She also neglects to mention subsection 10 of 287G, that's section 287G10 or 1357G10 of Title 8, which recognizes that this is not the only mechanism for cooperating with the federal government, and says that this in no way implies that the states are prohibited from taking other actions otherwise to arrest or detain illegal aliens. And of course, Congress also passed in the same year 8 U.S.C. 1373, which says the federal government must respond to any inquiry coming from any state or local law enforcement officer about a person's status. Again, recognizing that they want state and local officers to be helping to determine if someone is illegally present in the country, or to find people and be asking the questions. And I would end with this point. And this is something I didn't really hit me until several years working in this field. ICE does not patrol. It is a law enforcement agency that doesn't rove around looking for illegal aliens. The only patrols that will ever run into any illegal aliens in the United States are state and local police. ICE officers sit behind desks and they develop cases, and then they go out. They used to, under the Bush administration, go out and make raids. Now they don't do that anymore, at least not worksite raids. But they actually don't go out on the streets looking for violations of our immigration laws. The only eyes and ears that are out there are state and local law enforcement officers. And another secret that you don't hear too often is actually that in Maricopa County, which covers 70% of the population of Arizona, ICE gets most of its leads from the Maricopa County Sheriff's Office. Because they are out there finding so many illegal aliens, finding so many smugglers, they give the leads to ICE, and then ICE can go after the safe houses, the drop houses, and the smuggling operations themselves. And so there is a very good cooperative relationship, and ICE depends upon state and local law enforcement using their authority to help ICE. And when we start attacking states that are using that authority, then the executive branch is shooting itself in its foot. But again, as we've noted, many of you have probably heard that the ICE Agents Union has issued a resolution of no confidence in the leadership of ICE and the Obama administration's appointees, who are leading an agency that no longer wishes to enforce its laws. So I think you may find a slight disagreement when you talk about the federal government from the people in the federal government who actually try to enforce the law. Thanks.
We have 15 minutes left, and I'm under strict instructions to end at 5:15 so that everybody can change and get ready for the banquet. So if it's okay, let me exercise the moderator's prerogative to open up questions from the floor, because I know folks will want to do that. And I'll just simply reaffirm what I said earlier, which is please, we're going to insist on questions, and please don't make me look bad in violating that. The gentleman, please.
Ilya Shapiro from the Cato Institute. Now, I agree with Professor Kobach that the law is constitutional, except possibly one provision that is neither here nor there for my question. And I also agree with Professor Stock that it's bad policy, so perhaps that's an unusual position, joint position to have. But anyway, what I wanted to know is what other types of state laws would be constitutional in either of your views in this area, either to encourage entrepreneurs or highly skilled immigrants to jumpstart the economy, other types of enforcement measures. What can states do setting aside SB 1070?
Well, states do a lot of stuff already. States do, in fact, cooperate with federal immigration law enforcement under the provisions of 287G and under the Secure Communities Program, which the federal government basically gets the states to fingerprint people in their jails and send the fingerprints off to the feds. Some localities have tried to opt out of that program, but the federal government says that is not optional. You have to participate if your state is participating. There's also cooperation on a wide variety of issues. Kris is saying, well, you're not citing the statute. Well, I'd have to cite the whole INA. Congress has laid out such a complicated scheme. It's provided different visa categories for unauthorized immigrants to get status if they're crime victims. It's provided for temporary protected status for the president to declare whole countries worth of unauthorized immigrants to get work permits and stay in the United States lawfully because of foreign policy considerations in their home country. The litany goes on. Battered women provisions where undocumented women and even men too who can't get their U.S. citizen spouses to file papers for them are permitted to get status here in the United States. Arizona's law would disrupt a lot of that stuff, but states are permitted to cooperate heavily with the federal government in the prosecution of cases involving alien smuggling, in certifying people for various visas like the snitch S visa, the T trafficking visa, STU visas for crime victims. The states also play a role in regulating non-citizens present within their borders. We're in a room full of lawyers. Some states have successfully barred certain non-citizens from becoming members of the bar of their state, and those have been upheld. The state of Alaska has successfully barred undocumented immigrants from getting the Alaska Permanent Fund dividend, the money that's paid out to lawful residents of the state of Alaska every year because of our oil largesse. So there's a wide variety of roles, and I could probably best refer you to some law review articles that recite them. But the main point is when the states do regulate with regard to immigration, their efforts have to complement the federal government, not conflict with the federal government. And that's really the bottom line with all of this.
I'd like to refer you to a law review article too. It's my own. Funny, I wrote an article on that exact question. It's with Georgetown Immigration Law Journal, volume 22, page 459, and the title is Reinforcing the Rule of Law, What States Can and Should Do to Reduce Illegal Immigration. And basically I divide it into 8 areas and then give examples of different states that have done this, and then legal citation for courts that have supported these efforts. To quickly run through the 8 that I identify: 1, denying public benefits to illegal aliens; 2, denying resident tuition rates to illegal aliens; 3, prohibiting the employment of unauthorized aliens; 4, enacting state-level crimes that mirror federal immigration crimes, Arizona being one that's obviously in contention now; 5, enacting state-level crimes against identity theft; 6, providing state and local law enforcement assistance to ICE; 7, presuming illegal aliens to be flight risks for bail purposes; and 8, denying driver's licenses to illegal aliens. So there are lots of areas where they can act.
And the states, it's important to know, can also go the other way. California just had its provision providing tuition to undocumented immigrants and other residents of the state upheld by its own court. And that was
pending.
Probably it's probably going to withstand. States are allowed to do things that benefit immigrants also.
Hi, I'm Larry Berman. As an immigration judge, I appreciated Professor Stock's description of how the law works. Although I would point out that most of the problems that you mentioned are problems of enforcement generally and not particularly Arizona. In fact, most of the examples you gave had nothing to do with Arizona. But I actually have a question for the panel that's been bothering me ever since this Arizona suit's been filed. The Constitution specifically states that an action filed against a state is within the original jurisdiction of the Supreme Court. How in the world could this case have been litigated in Phoenix? Thank you.
I can answer that. And it's a very good question. A lot of people were asking it. There's actually some pretty old case law, and I can't remember the name of the case off the top of my head, but this issue was litigated in the 50s, if I remember correctly, and I think it was the Supreme Court, or at least several circuits, interpreted that provision of the U.S. in Article 3, giving the Supreme Court original jurisdiction in cases where a state is a party, as non-exclusive. so that the lower federal courts could also have jurisdiction over such cases. And some people were urging the state of Arizona to contest that point and try to reopen that can of worms, but they decided not to.
And I don't know if Jim wants to comment on that. What do you think would happen if they actually had a trial in the Supreme Court?
A trial? I think I'm going to not comment on what would happen in that case, but thank you. Sir.
David Chapman from Fargo, North Dakota, immigration lawyer and an immigrant as well. I have a question that's primarily for Margaret. With Congress's stated policy under Section 212, where it says the Department of Labor must look out for the wages and working conditions of Americans and lawful permanent residents, and also the regulations that prohibit the hiring of undocumented aliens, specifically with the Arizona provision in SB 1070 that talks about criminalizing taking a job and being undocumented. I think it makes it a misdemeanor at some point in there. How does that conflict with the federal law as opposed to complementing it, given Congress's stated intent on that, and also the current administration's approach in terms of bypassing a lot of these smaller deportation cases? Although I'm from North Dakota, I know in Houston, for instance, ICE attorneys have been going into immigration court and saying, okay, do you have any convictions? No. How long you been here? 2 years? We pass. You know, have a nice day, and turn them loose. How does it conflict with Congress's intent?
You know, that particular provision I think is probably going to be the one that is going to be most interesting for people to watch, but it appears that the way the Arizona law is designed, it won't fit neatly within the complex. It's basically a field preemption argument that because Congress has passed such an extensive set of rules and regulations regarding who gets to work and who doesn't, and although it is illegal for some undocumented immigrants, not all, to be working in the United States, there's still some that are, you know, grandfathered from prior to 1986. Undocumented immigrants also have some rights if once they are employed, rights to certain protections under federal law against unpaid wages and that sort of thing. And so, you know, I think what the federal judge ruled in that case, and you go back and take a look at it, is basically that what Arizona is trying to do is going beyond and conflicting with this complex scheme that was enacted by Congress. That one, the Ninth Circuit, I'm not quite sure how they'll go on that, but I do think DeCanis v. Vika has, you know, the reasoning under it in terms of the philosophy laid out in the decision is probably still applicable, but the actual court decision is probably, since it predated IRCA, is suspect.
Can I just chime in on that one too? Yeah, I think it's an interesting argument. There too, the federal government is being, shall we say, creative in their preemption argument. They're arguing that Arizona's law making it a misdemeanor to unlawfully seek employment when you're an unauthorized alien goes beyond the scheme envisioned by Congress. But there the argument is not preemption through executive inaction. There they're saying preemption occurs through congressional silence. That if Congress doesn't speak in an area, then Congress has preempted by declining to speak. Now that's a very dangerous notion if you think about it. Then preemption, you have this sort of dormant preemption concept, which would push the states off of all sorts of fields if congressional inaction. What Congress did in 1986 with IRCA was made it a crime under certain circumstances to knowingly hire or employ unauthorized aliens, which is the term that is used, but didn't go into the subject of whether the alien has committed an offense by knowingly seeking unlawful employment. Right. The other point about field preemption, I don't think field preemption does apply here because IRCA did leave several holes in it, most notably the one that the Ninth Circuit, holes in the field where states are still allowed to operate, and most notably the one that was at issue in the Arizona Legal Workers Act case that's now before the Supreme Court, which is may a state take away business licenses from companies that are knowingly employing unauthorized aliens. The Arizona Act of 2007, which I also assisted in the drafting of, there we looked at an exception that was carved out by Congress in 8 U.S.C. 1324 AH2, which says that states can take away business licenses from companies, employers who hire illegal aliens. So since Congress has allowed for the states to be on the field, it's quite difficult for a field preemption argument to work, because you're saying they're simultaneously allowed on the field, but they're pushed off the field too.
No, it's because Congress put the exception in the statute for that, and it didn't put an exception in for the other stuff. So it's pretty straightforward.
My question is for Kris Kobach. What can we do to educate the public to the effect that there is a war going on in the southwestern part of our country and we're being invaded? And second part of the question is, what can we do to counteract the fact that the President of the United States, and actually his predecessor, in spite of their window dressing and deporting a few people, really are not interested in enforcing the law, and in effect are actually aiding and abetting the criminals who are invading our country?
Well, you know, it's an interesting point. I mean, this war it literally is a war, and going on in Mexico, and the Mexican federal government is having real difficulty asserting authority over its own territory. And the drug cartels are giving the Mexican army its greatest challenge since it has come into existence in asserting control. And I don't need to go into the statistics. I'm sure you've all heard them, because it's hard to avoid them on any of the networks if you watch the news or read the papers at all. But it is extraordinary the amount of mayhem and death that is happening south of the border, and that is spilling across the border in some of the border cities and border counties. So I think the public is certainly aware of it and becoming more aware of it. The question is, will the executive branch, and to a lesser extent Congress, become sufficiently concerned about it that they will try to do something and recognize the importance of, again, state and local law enforcement. I made the point earlier about how the federal government ICE doesn't go on patrols looking for illegal aliens. The analogy is like this: if you're bringing in, you're a smuggler and you're bringing in your pollos, your human cargo. Once you get past the 100-mile zone or so where the Border Patrol operates, you're free. You will never run into a federal law enforcement officer looking for your violations of immigration law. Your only chance of running into any law enforcement officer will be a state or local law enforcement officer. It's like a team, it's like a baseball team that has pulled the outfield and is just playing with an infield. All you have to do is get beyond the infield and everything's a home run.
That's simply not true, Kris. And I gave the Amway example. That was in the middle of Nebraska, and it was an ICE agent who was, at McDonald's and called in the troops, and they came in and right in the middle of Nebraska and grabbed everybody on the bus.
In a very unusual case where an ICE agent happened to be, was not out there patrolling looking for it, but where an ICE agent by accident.
Protection patrols,
you don't have customs and border protection. You don't have. They aren't
Border
roving
Patrol
around
sectors
within their sector. Yeah, of course.
Yeah,
That's
the
what I'm saying. It's
sectors
like the
reach
infield.
well into the United States. I mean, I've been in southern Vermont and had checkpoints in southern Vermont on the interstate highway. People pull you over and check you to see whether.
Get beyond 100 miles, you won't find many, and come to Kansas or Missouri, you sure won't find too many there either.
It's pretty far.
But as far as the public, how do we inform the public? That was the other point of your question. I think actually in some ways the public is really well informed on this issue. There's been so much coverage of it. You saw this during the 2007 and 2008 debates on the DREAM Act and on the other amnesty proposals. You actually had the public, because of the internet and because of certain cable news and talk radio, you name it, there was so much information out there that the public, I was amazed at how the public was in many instances better informed than members of Congress. You'd hear members of Congress talking about the issue, and it was clear that they were unaware of certain provisions of the bill that the public was hammering them with all these emails that were flooding and calls that were flooding and faxes that were flooding Capitol Hill. So I think public information is actually unusually high in this area compared to congressional information.
I think we put out some misinformation, though, tonight, which is that there's no enforcement going on. In fact, the Obama administration, as I said, is breaking records on the number of deportations. They've deported more people this past year than ever has happened in United States history.
Cases which were initiated before they came into office.
No,
yeah.
and they're deporting more. Even as we speak, they're going to break 400,000 this year in terms of deportations.
Look at when they were started.
To claim that this isn't happening, and on top of that,
Wait. I think you've all heard about the Houston area, and we just heard one of the questions from North Dakota.
Kris, what you want is all these undocumented immigrants who are, working at Walmart to get deported rather than drug dealers, murderers, rapists, pedophiles.
Let's stick to the point you just made. You said that they're breaking records. In the Houston sector, and as the one questioner just mentioned in North Dakota, the administration is now having ICE attorneys drop cases by the thousands.
Against
17,000 cases.
minor violators, so that they can
Sure.
put the resources
Right.
on the bad guys.
You just told us they were breaking all these numerical records.
Yeah,
They're
they
actually
are.
going into certain areas, and they're dropping the cases midway through the deportation proceeding, the removal
Right.
proceeding. They're dropping them in the
Because
middle.
Congress has only given them the resources
how
to
are they
detain
deporting-
and deport 400,000
So how are they
people throughout
bringing
the
a
whole
record
country,
number of cases?
And they're trying to deport the murderers, the rapists, the drug dealers, the bank robbers, you know, the bad guys.
Unfortunately, we are out of time, and unlike in a game of football, we don't have overtime today. Clearly an emotional issue. Please join me again in thanking the panel. This was a wonderful debate, a real testament to the society. Thank you.